Congratulations. I will request all you esteemed guests and distinguished dignitaries to kindly come back to the stage and take your seats. तालियों की गूंज के साथ हम सभी बच्चों को एक बारी यहाँ पर प्रोत्साहित करते हैं. Ladies and gentlemen, we have with us our resource person, Mr. Milind Sathe, Senior Advocate, Bombay High Court, practicing at Supreme Court of India and Bombay High Court since 1983, designated Senior Advocate by Bombay High Court in 2005. He has appeared in several public interest litigations, legal aid matters, and as amicus curiae. He has also contributed several articles on law, business, and commerce. I request Mr. Milind Sathe, Senior Advocate, Bombay High Court, to address this august gathering.
Honorable Chief Justice Shri Swatantra Kumar, I would always refer to him as our Chief Justice of Bombay High Court. Later on, of course, Judge of Supreme Court and Chairperson of National Green Tribunal. My friend Justice K.K. Tate, the member, Maharashtra State Human Rights Commission, Mr. Saeed and Mr. Sanjay Kumar, Ms. Vajpayee, the resource person, the dignitaries of the dais, my student friends, my special friends, ladies and gentlemen. My greetings to all of you on Human Rights Day, celebrated on 10th December every year to commemorate the adoption and proclamation of Human Rights Declaration by United Nations General Assembly on this day in 1948. I'm going to briefly touch upon the journey of human rights and its evolution through history. Human right of a person born as a human being to live freely with liberty and dignity should have been the norm of civilization. However, unfortunately, it has not been so. Several kings, several tyrants have been treating humans as the assets and their properties. However, historically, we find about 4,000 years back a declaration which was signed on a clay cylinder by King Cyrus of Persia when he won that kingdom and he released all the slaves. And he declared, you are free to live like human beings, you are free to profess your liberties, you are free to profess any religion. This is the first document which is about 4,000 years old in which the human right has been acknowledged as a written authority by the king. Since then, there has been an evolution of human rights, but the other document historically we always recall is the Magna Carta, which was signed in 1215. Very few people know that Magna Carta was very short-lived. It did not even survive few months because subsequently it was declared void by another authority. Thereafter, there have been several human rights documents such as the United States Constitution, United States Bill of Rights, the French Declaration, etc. And then, of course, we come to 1948, the Human Rights Declaration by the United Nations. Despite these declarations, the violations of human rights continue unabated. And that is what drove the United Nations, which was also in its formative states post the Second World War, which ended in 1945, in formulating the principles of recognition of human rights. Incidentally, by 10th December 48, when the Human Rights Declaration was signed, our Constituent Assembly had already debated, discussed, and finalized the Fundamental Rights chapter, that is Part 3, and the Directive Principles of State Policy in Part 4. But several Indian delegates who were part of the United Nations delegation, they participated and made substantial contribution to the contents of Human Rights Declaration, which was signed on 10th December 1948. In 1950, thereafter, the United Nations passed a resolution and urged all states to celebrate 10th December as Human Rights Day, and that is how since then we all celebrate the Human Rights Day. Now, why do we celebrate a particular day, particularly the Human Rights Day? It is not tokenism. It is not a ceremonial. It is reminder to us, reminder to everybody, reminder to all people in authority, reminder to those who violate human rights that human rights are inviolable. Human rights are the most basic core of any human, to live with dignity and proper dignity and proper life. That's the concept which we need to remind ourselves, and that is why we celebrate Human Rights Day. Now, evolution of human rights in India is akin or is almost parallel with the evolution of law by the Supreme Court and the High Courts in the country. Our Constitution in Part-3, which is a chapter on fundamental rights, has at least 6 rights which have been guaranteed, which is the substance of Human Rights Declaration. First and foremost, the right of equality under Article 14, the 6 freedoms under Article 19, and of course, the right to personal liberty under Article 21. Besides that, we have Articles 20 and 22, again dealing with the personal rights and detention, etc. There is abolition of untouchability, prevention of child labor, prevention of forced labor, etc. These are all guaranteed rights under the Constitution, under Part 3 of the Constitution. Unlike Magna Carta, which I mentioned did not take off after its inauguration in 1215, Article 21, which is a repository of all human rights, I would say, did not take off for almost 20 years. In fact, the first decision of the Supreme Court in 1950 in A.K. Gopalan's case considered and interpreted Article 21 in a very narrow compass and said that Article 21 declaring that no person shall be deprived of his life and personal liberty without procedure established by law. And the Supreme Court said, if a law is made and procedure is prescribed and that procedure is followed, the violation of life and liberty is permissible by law. They did not read into Article 21 any more substance, any more life to inject the life into the right of human being. It took another 20 years till bank nationalization case, that is R.C. Cooper's case, when Supreme Court virtually overruled A.K. Gopalan's case and said Article 21 has more content than what its only plain language says. Article 21 then again was finally interpreted, and it took expansive steps from Maneka Gandhi's case in 1978. That was a historic moment in the history of our evolution of Constitution as well as evolution of Supreme Court. Unfortunately, before that, during emergency, there was a black day in the history of Supreme Court. Supreme Court delivered a judgment in case of ADM Jabalpur, in which the Supreme Court said at that point of time, the fundamental rights were suspended because of proclamation of emergency. Article 14, 19, 21 were suspended. And Supreme Court accepted the argument of Union of India through Attorney General that even if a person is shot dead, he has no right to move the court. He has no right of any redressal, of any grievance redressal mechanism. That is the position which was accepted by the Supreme Court in ADM Jabalpur's case. Fortunately, that judgment is no more good law. Justice Chandrachud, who was a part of that bench, who later on became Chief Justice of India, Justice Y.B. Chandrachud, he later on publicly acknowledged that it was a grave mistake on the part of the Supreme Court in delivering that judgment in ADM Jabalpur case, which is actually a blot on the human rights movement. But since then, post Maneka Gandhi's case, the Supreme Court has redeemed itself. In fact, Supreme Court and the courts in our country, and subsequently I will deal with about human rights commissions, national as well as state, have done stellar service in protecting, safeguarding, and propagating human rights. Before 1950, I must mention, before 1978, I must mention two covenants which were adopted by the United Nations in 1966. The first was International Covenant on Civil and Political Rights, and the second was International Covenant on Cultural, Economic, and Social Rights. These two rights, then there were two subsidiary covenants which required states, which are of course optional, not mandatory, to abolish death penalty and to entertain direct complaints from individuals throughout the world by the United Nations. So these four charters, along with UN Charter on the Human Rights, that combined is known as the Bill of Rights of Human Rights under the United Nations. So that's a very, very strong documentation by the United Nations. The question comes about implementation at the international level. But I'm going to focus about India today and starting again from Maneka Gandhi's case in 1978. As I mentioned, Article 21, which had not undergone any amendment, which stands as it is, which was enacted in 1950. It's one simple article, but very potent and important. No person means whether you are a citizen of India or not, whether you are a foreigner, whether you are enemy, alien, etc., it doesn't matter. As long as you are on Indian territory, your rights are protected. No person shall be deprived of his life and personal liberty without procedure established by law. That article has been interpreted by the Supreme Court. It has injected life into that article to make a life of every human being in this country meaningful and give a meaning to not only to that article, but the Charter on Human Rights also. I would classify the evolution of Article 21 from 1977 into three parts. The first part from 77 till 1980, the Supreme Court dealt with large number of cases in respect of personal liberty. And those cases involved about large number of detainees languishing in jail without trial. Unfortunately, that situation continues. If you read today's headlines in newspaper, again, the Supreme Court has lamented about large number of people languishing in jails as under trials, without charge sheets being filed, without trials being concluded. Supreme Court had taken cognizance of this case way back in 1980 and had directed release of all persons. At that point of time, Supreme Court found large number of persons were in jails as under trials for a period larger than what their possible sentence could have been. That was something shocking, and the Supreme Court stepped in and directed release of all those persons. Then there were issues relating to prisons, treatment of the inmates in prisons, the treatment of women and children inmates in the prison, etc. Supreme Court evolved large number of guidelines on these aspects. See, then there were bonded laborers. In respect of that, the Supreme Court issued directions, etc. I have heard Justice P.N. Bhagwati when he was Chief Justice of India, when he had come to Bombay. And that's the first time, in fact, I heard him. And it was a moving speech given by Chief Justice P.N. Bhagwati when he narrated some stories about his travel from Calcutta airport to Calcutta High Court, and he noticed large number of people on the roadside so being subjected to torture by the contractors as well as living in inhumane conditions. And that moved him, and that's where he started the evolution of this public interest litigation and about entertaining the public interest proceedings without questioning about the locus. Justice Tater mentioned in his remarks that the Human Rights Commission entertains complaints on simple paper. No procedure is required to be followed. No court fee is required to be paid. No lawyer is required. We all famously remember as a young lawyers that Justice Bhagwati mentioning that a postcard returned to Supreme Court of India was entertained as a public interest litigation to entertain the grievances of the persons whose personal liberties were violated. So that era, that decade from 1978 till about 1990 saw large number of cases in which the Supreme Court and the High Courts recognized various facets of personal liberty and life to give meaning to human life and personal liberty. Post 1990, the Supreme Court considered another facet which is also important for a human society, that is the public governance. The authorities performing appropriately, the public person in public life should have the integrity, and the Supreme Court considered those cases about the corruption against high places, the famous case being the Jain Hawala case, which was monitored by the Supreme Court. So large number of cases in that decade related to public governance, which Supreme Court considered and regarded as a facet of personal liberty, because whatever is required from the governance, from public authority, from society, for a person to live with dignity is a part of personal liberty and therefore human right under Article 21. Then Supreme Court thereafter decided, not thereafter in the sense not exclusively but parallelly, started dealing with issues relating to environment. Environment is an equally important part of personal liberty, therefore human rights. Right to a clean environment, right to proper ecology, right for preservation of flora and fauna of our society, of our country, then clean cities, garbage-free roads, all these facets were read by Supreme Court in personal liberty under Article 21. In fact, the first case about this garbage removal was entertained by Supreme Court way back in 1980 in Ratlam Municipal Council's case, where the corporation complained to the Supreme Court that we do not have funds to clean the garbage in the city of Ratlam. And Supreme Court castigated the Municipal Council, saying that the authorities cannot say that they do not have funds to perform their duties and functions as statutory authority. If they are not in a position to do so, they should shut their shops. That were the harsh words used by Supreme Court in Ratlam Municipal Council's case. And that's where Supreme Court entertained that complaint way back in 1980. But post that, in relation to environment, Supreme Court has entertained large number of cases for enforcing the laws relating to environment. The first classic example is in respect of what in Mumbai is dear to everybody, is the coastal regulation zone. There was a notification for enforcing the coastal areas throughout the country, and that notification was not being enforced. The Supreme Court in the Enviro Action Group cases, a series of orders passed by the Supreme Court sought enforcement of the coastal regulation zone. Notification made in 1991 finally, through the intervention of the Supreme Court, was finally implemented from 2000. Similarly, the Forest Conservation Act of 1980, it was not being implemented, but through Supreme Court's intervention in Godavarman's case, Supreme Court implemented the Forest Conservation Act and saw its effective enforcement throughout the country. Another issue in respect of environment impact assessment notification, that for any project which requires environmental clearance, those laws, Environment Protection Act, rules framed thereunder, were not being implemented, and the Supreme Court was the guardian for all that in our country. Subsequently, of course, several laws are passed, several tribunals are constituted, including the National Green Tribunal, of which our Chief Guest Justice Swatantra Kumar was the first chairperson at Delhi. That tribunal is doing a stellar job in enforcing the environmental laws. And why I'm mentioning is this because the Supreme Court has read all these facets as part of Article 21, which is a codification of human rights in our country, in our constitution. So that's where the Supreme Court has stepped in. A large number of cases, this topic is so enormous, we can go on and on. Now coming to the issues about how the human rights commissions have enforced the human rights and the rights under the Constitution, it's a very, very interesting story. After the Human Rights Declaration was made in 1948, United Nations found that it had no teeth to enforce that law. The nations had to adopt the declaration and make appropriate arrangements for its enforcement, and that was not being done. So in 1965, they adopted what is known as Paris Principles. Now, Paris Principles are the principles on which the bodies for enforcement of human rights are to be established. And they have established a principle. These Paris principles include that the body for enforcement of human rights, that is now we have the National Human Rights Commission and States Human Rights Commission, they should be independent bodies. Their members should be so that they are not subjected to government control. They should be from diverse fields, from environment, administration, the policing, etc., so that enforcement of human rights can be effectively implemented. So those Paris principles embody what a Human Rights Commission or any body for enforcement of human rights should be. Despite these principles having come into effect in 1965, it took another 25 years for India to pass the law in 1993, that is the Human Rights Protection Act of 1993, which has recognized the need to enforce the human rights. The Statement of Objects and Reasons of the Act proclaims that from 1948, the evolution of human rights has taken place and it is necessary to augment its implementation, although the constitutional courts are doing so already. So the Human Rights Commission were directed to be set up. And in 2001, as was mentioned earlier, the Maharashtra Human Rights Commission was established. The National Human Rights Commission was established in 1993 itself. Now, the Commission under Section 12 has enormous powers. Now, questions come before the court, particularly the Constitutional Court, High Court and the Supreme Court, about the conflict of jurisdiction of the commissions and the constitutional courts. Undoubtedly, they do have overlapping jurisdiction. But in cases of enforcement of human rights, the overlap of jurisdiction and the technicalities should not be a matter of concern. Anybody who has a grievance about violation of human rights should be able to approach any court, whether it is a constitutional court, whether it is Human Rights Commission, etc. And therefore, the Supreme Court in D.K. Basu's case has accepted that human rights commissions would have a parallel jurisdiction as long as they do not deal with a case which is directly pending before the High Court or which is expressly outside the jurisdiction of the National or State Human Rights Commission under Section 36, namely the property disputes. All other cases would fall within the jurisdiction of Human Rights Commission under Section 12, and that section has widest amplitude of jurisdiction to entertain and seek redressal of human rights violations. As Justice Tater mentioned, there is no procedure required to be followed, no court fees required to be paid, no advocates are required to represent a person before the Human Rights Commission, a plain and simple procedure to entertain a grievance, investigate, and pass appropriate orders. There were two amendments to this act in 2005 and 2019, which gave more teeth to the Human Rights Act. The Human Rights Commissions now can approach the court where the cases are pending in which there is a violation of human rights and assist that court with the leave of that court, of course. And human rights can be very, very effectively enforced and implemented. Large number of cases have been taken cognizance of both state commission as well as national commission, and that they have, like, there are several cases, like there was a poisoning during the midday meals in some schools, the mass graves found in Gujarat, etc. So there are a large number of cases on the basis of which the commissions have taken cognizance of. I remember when I was faculty at Government Law College, this was in 1991, I used to tell my students to bring a newspaper and find out a news item which would have a constitutional bearing, and then we would discuss that issue in the class. Now, today you open a newspaper and you will find that there are issues on which there is a violation of human rights. Unfortunately, in the 75th year also, we still see the grossest violation of human rights. We still see the community homes of lower caste, scheduled tribes, scheduled castes being burnt. We still see atrocities being committed on the members of the lower caste and scheduled tribe, atrocities against women. All that still continues unabated. The courts and the Human Rights Commission have been stepping up and effectively enforcing it, but still the enormity of that problem is so much that the efforts by the courts and the commission are still not sufficient. It is for us, all of us, the society and the citizens, we'll have to step in, we'll have to change the mindset, we'll have to change the outlook at how we look at our sisters and brothers. We have two effective acts, the Civil Rights Protection Act of 1955, which prohibits the untouchability, and we have Prevention of Atrocities Act against scheduled tribes and scheduled tribes. We have large number of laws. We have a wealth of judicial decisions, and yet the violations of human rights continue unabated in our country. It is for us citizens to help the courts and the commissions who are doing excellent job in their jurisdictions to assist them, to help them, to bring to their notice these violations, and that would be our pledge to the human rights commitment which India has undertaken under the Universal Declaration of Human Rights. That would be our dedication, that would be our pledge, that would be our service to the society, and a real commemoration of Human Rights Day on 10th of December. Thank you, ladies and gentlemen.